Good morning, this is your Kelso Report for Tuesday, November 8th, and I'm your host, Clark Kelso. The United States Supreme Court has struggled over the past 20 or 30 years to maintain clear distinctions between constitutional duties, which government owes to the people, and non-constitutional, tort-like duties, which government owes to the people. The distinction creates some very hard case law, and our feature case for today, Campbell v. State of Washington from the Ninth Circuit, is a good example. The decedent was developmentally disabled and voluntarily entered a Washington state program known as SOLA, which stands for State-Operated Living Alternatives. Under this program, she rented a room in a house with several other developmentally disabled residents, and they were cared for pursuant to a personal support plan, which described in detail for the SOLA caregivers how they should support and care for a program participant. In the decedent's case, early PSPs established cautions about her use of the bathroom and bathtub, including monitoring while in the bathtub. But by 2006, the PSP did not include a bath-specific protocol, but did include a general instruction to check regularly on her safety. Well, the decedent died tragically on October 10, 2006, by drowning in the bathtub. She had been directed by one of the state caregivers at the end of the day to take a bath around 8 p.m. that evening. The caregiver then went to the kitchen to prepare medications for one of the other residents. The decedent was visited several times over the next 10 to 15 minutes. At the time of the last visit, the decedent was relaxing in the bathtub, as was her practice. The caregiver told her to begin washing herself, and the caregiver left. When someone returned only 5 minutes later, the decedent was not breathing. The caregivers immediately pulled her out of the tub, called 911, and performed CPR. Although the paramedics were able to restore her heartbeat after a week in an ICU, she was removed from life support and pronounced dead. The decedent's mother sued the state caregivers under Section 1983, alleging that they had deprived the decedent of her 14th Amendment rights to substantive due process. The district court granted the defendant's motion for summary judgment, holding that the defendants had no constitutionally required duty of care towards the decedent. The Ninth Circuit affirmed, with one judge dissenting. The law here is pretty well settled. As a general matter, although the Constitution protects a citizen's liberty interest in her own bodily security, the state's failure to protect that interest does not violate the 14th Amendment unless one of two exceptions applies. Number one, the special relationship exception, or number two, the state-created danger exception. The special relationship exception applies when the state takes a person into its custody and holds him there against his will through incarceration, institutionalization, or other similar restraint of personal liberty. The theory here is that the state, by virtue of the involuntary restraint, assumes some responsibility for the person's safety and general well-being. The Ninth Circuit majority held that there was no special relationship here because the decedent was a voluntary participant in the SOLA program. She was free to leave the program at any time. The dissent argued that her liberty actually was restrained because the caregivers locked the doors to the house, maintained direct control over many of her activities during the day. But, as the majority noted, the decedent voluntarily submitted to all of those controls in the interests of her own safety. So from a constitutional perspective, she was not being held against her wishes, and the heightened duty of constitutional care was not triggered. The majority held that the second exception, the state-created danger exception, also did not apply, because the caregivers did nothing affirmative to increase the decedent's risk of injury. As far as they were concerned, the bathing that evening was nothing other than a routine action, and they checked upon the decedent frequently. Now, in retrospect, the absence of a bathtub-specific protocol requiring constant monitoring was a mistake. But that is not the sort of indifference that triggers constitutional accountability for the injury. As the majority noted, quote, "The decedent's death was tragic and unfortunate, but that does not render defendants, her government caretakers, liable under Section 1983 where defendants did not put her in the way of a harm of their own creation, close quote. Instead, the court explained, while she may well have a complaint against defendants under Washington tort law, we decline to constitutionalize a state tort. Well, as you can see, this is a hard case. It may be the right result under the law, but it still is a hard result. We'll see if the Ninth Circuit decides to take this one up on an en banc. And now for our one-liners. We have quite a few today. First, in the area of arbitration. In KPMG versus Kachi, the United States Supreme Court, in a per curiam opinion, vacated and remanded a case to the District Court of Appeal in Florida involving the issue of whether certain claims were arbitrable. The Florida Court of Appeal had focused on 2 of 4 claims that were not arbitrable, and apparently determined on the basis of the conclusion that just those 2 were not arbitrable, that, well, none of the claims were arbitrable. That approach is contrary to federal case law, which requires that if a dispute presents multiple claims, some arbitrable and some not, the arbitrable claims must be sent to arbitration, even if that leads to piecemeal litigation. On remand, the Florida Court of Appeal will examine the remaining 2 claims to determine whether either requires arbitration. Next, in the area of habeas corpus in Bobby versus Dixon, the United States Supreme Court issued another per curiam opinion. That happens early during the Supreme Court's term, of course. This time, to reverse a Sixth Circuit decision which had granted the petitioners writ of habeas corpus. The Sixth Circuit cited 3 alleged errors by Ohio state courts, and the Supreme Court found that none of these constituted error, much less the sort of unmistakably clear error required by the Anti-Terrorism and Effective Death Penalty Act. In particular, the Sixth Circuit incorrectly held that when a person who is not in custody refuses to speak to police without a lawyer being present, any subsequent custodial interrogation without a lawyer is forbidden. Well, that's just not the law. The Supreme Court has never held that a person can invoke his Miranda rights anticipatorily before being in a custodial setting. The second mistake the Sixth Circuit made, it held that the police violated due process by urging the defendant to cut a deal before his accomplice did so. The Sixth Circuit held that violated due process. Well, there is simply no precedent to support that conclusion. Third, the Sixth Circuit incorrectly interpreted the Supreme Court's decision in Oregon versus Elstad, where the court held that police could not secure a non-Mirandized confession from a suspect and then immediately Mirandize the suspect so he could simply repeat his confession, with the clear intention of diluting the impact of the Miranda warning. In yesterday's case, the defendant had confessed to a completely different crime, burglary, before being Mirandized. He was subsequently given his Miranda warnings and then voluntarily confessed to murder. The Sixth Circuit concluded that those circumstances violated Elstad, and the Supreme Court disagreed, holding that because the second confession was on an entirely different crime, the Miranda warnings had not been diluted. Our third one-liner is in the area of remedies, in DeTullio versus Bohm, where a majority of the Ninth Circuit held that the Trafficking Victims Protection Act permits recovery of punitive damages in addition to compensatory damages. The statutory language here provides that an individual may bring an action under the Act, quote, to recover damages and reasonable attorney's fees, close quote. The majority held that the reference to damages meant both compensatory and punitive damages, since Congress likely intended by the reference to damages to include all types of damages ordinarily recoverable in a civil action. There was a dissent here which pointed out that an earlier version of the language, which ultimately was enacted as the TVPA, referred to, quote, actual damages, punitive damages, reasonable attorney's fees, and other litigation costs reasonably incurred, close quote. The dissent, of course, argued that this legislative drafting history clearly indicated that punitive damages should not be available. That language was dropped in subsequent drafts. Of course, on the other hand, when Congress wants to forbid punitive damages, It also certainly knows how to draft language to accomplish that result, as it did, for example, in the Federal Tort Claims Act. I would say about the only thing we know for certain is that whoever drafted the final language of the Act did a pretty poor job. They drafted language that was sure to force the courts to guess about congressional intent, which is why we have a majority opinion along with a dissent. Next, an area of anti-SLAPP law. In Roberts versus McAfee, the Ninth Circuit held that the defendant's anti-SLAPP motion should have been granted in its entirety, leading to dismissal of plaintiff's claims for malicious prosecution and defamation. The plaintiff was the former general counsel to the defendant. When a scheme of large-scale backdating of stock options came to light, the defendant's board of directors conducted an independent investigation leading to the plaintiff's termination and issuance of a press release announcing the termination. Plaintiff was then criminally prosecuted, but found by a jury to be not guilty of the crime. He then sued the defendant for malicious prosecution and defamation arising out of the press release, and the defendant filed its anti-SLAPP motion. The Ninth Circuit concluded that the defendant had probable cause to believe the plaintiff had committed a crime at the time they terminated him, and the court found that the defamation actions were barred by the applicable statute of limitations. In these circumstances, the plaintiff could not prove that he was likely to prevail in his claims, so the Ninth Circuit directed that the anti-SLAPP motion be granted and the plaintiff's claims dismissed. Next to the area of appellate jurisdiction in United States v. Sabalos, the defendant, who pled guilty to one count of conspiracy to distribute methamphetamine, requested that the district court recommend a Southern California housing designation to the Bureau of Prisons. At the sentencing hearing, neither counsel nor the court addressed this topic. A week later, the defendant and the government filed a joint stipulation asking the court to revise the judgment and commitment order to include the designation recommendation. The district court denied the request, and the defendant appealed. Consistent with rulings from other circuit courts, the Ninth Circuit held that it lacked jurisdiction to review a district court's non-binding housing recommendation, because the non-binding recommendation is actually not part of the sentence, so the court dismissed the appeal for lack of jurisdiction. The lesson here is simple. If you want a non-binding housing recommendation as part of the sentence, you had better raise the issue at the sentencing hearing, since you may not get a second chance on that issue. Next, attorney's fees. In re Marriage of Guilardi, the 6th District upheld an implied waiver of need-based attorney's fees based on language in a marital settlement agreement that expressly authorized attorney's fees to the prevailing party and then waived all other claims between the parties. The 6th District held that the need-based fees under Section 2030 of the Family Code had been waived by the settlement agreement, even though that waiver was implied rather than express. Next, in the area of criminal law, in People v. Hall, the 2nd District reinforced that it is the trial judge who is ultimately responsible for determining proper instructions to the jury. The defendant here was convicted of second-degree murder of a child a little over a year old, and of the assault on that child causing death. The prosecution and defense had agreed that the trial court should instruct the jury on an uncharged, lesser-related offense of child abuse, but the trial court refused. California law does not permit a jury to be instructed on uncharged, related offenses, unless both parties agree to the instruction. But in this case, the 2nd District held that even if both parties do agree to the instruction, it remains the trial court's ultimate decision whether to give an instruction on an uncharged, lesser-related offense. Our last one-liner in the area of government law, public works, in Reliable Tree Experts v. Baker. The 1st District held that a contractor who entered into an agreement with Caltrans to prune and remove diseased trees along a stretch of state highways was bound by the state's prevailing wage law, and therefore had to pay its employees at prevailing wages. The contractor tried to avoid this obvious conclusion by arguing first that the contract was not for a public works, and second that the work did not qualify as maintenance. Both of these facially implausible arguments were contradicted by the language and obvious application of the relevant statutes, so the First District affirmed the Superior Court's rejection of the contractor's petition for a writ of administrative mandamus. Now, the United States Supreme Court granted review in a couple of issues yesterday. First, the United States Supreme Court granted review in two cases raising the same issue, Miller v. Alabama and Jackson v. Hobbs, to decide whether the Eighth Amendment prohibits sentencing to life without parole a minor who was 14 years old at the time the minor committed a homicide. The Supreme Court has previously held that the 8th and 14th Amendments prohibit sentencing a juvenile to death. That's Roper v. Simmons from 2005. The court extended the Roper decision in 2010 in Graham v. Florida, holding that juvenile defendants cannot be sentenced to life imprisonment without the possibility of parole for non-homicide crimes. By granting review in Miller and Jackson, the court has signaled that it will now decide the case that falls in the middle, a homicide crime committed by a 14-year-old who was then sentenced to life without possibility of parole. And finally, in the area of civil rights and fair housing, the court granted review in Magner v. Gallagher to decide whether disparate impact claims are cognizable under the Fair Housing Act, and if so, how the burden of proof should be allocated between plaintiff and defendant. The case arises out of an interesting complaint filed by an owner of rental properties against a city, alleging that aggressive enforcement of the city's housing code will increase their costs to rent, decrease the number of units they can make available to rent to African Americans, which ultimately will result in a violation of the Fair Housing Act because of disparate impact. Well, that's it for today's Kelso Report. Have a great day in the law.